Hello everyone and welcome back to the preparation of CLAT examination. In this particular lecture series, we are discussing about the important aspects of the CLAT examination, specifically focusing our agenda towards the legal reasoning portion of your CLAT examination. In this particular lecture series, we have been talking about a number of legislations. We have discussed about the contract, the constitution, the criminal laws, and we have also discussed the law of torts, the famous case laws which are important, the major amendments that has been done in regards to those legislations, the important provisions, the important principles. Majority of the things has been discussed, and from this lecture series onwards, we are actually focusing over the international law. International law perhaps takes an important portion if you talk about your CLAT examinations as such. So CLAT examination, if you talk about the syllabus, as we have already discussed in the very first video of this particular lecture series, that international law also is a part of the syllabus of your CLAT examination, which CLAT examination, legal reasoning portion of your CLAT examination. So we are starting with the chapter of, we are starting with international law, and what exactly are the things that needs to be studied in the international law is something that we are going to discuss in today's lecture. So basically, we'll have an overview as to what exactly we need to understand and what exactly we need to study in regards to your CLAT examination, especially focusing over the international law concept. And that is why it becomes important for you to understand that what exactly are the things that we need to study, especially in regards to international law. Because when you will be getting questions in your CLAT examination, so it is not like that everything will be coming from constitution, everything will be coming from contract, and the segregation of marks for the different subjects will be different. But international law, as I've already informed you, takes an important role whenever you are supposed to prepare for examination, competitive examination, especially focusing over CLAT. And that is why it is important for all the CLAT aspirants to get a clear idea that what exactly we need to study, what exactly is important when we talk about international law. Because if you talk about international law concept is not a very small one, but it is a very wide concept. People take more than years then to understand that what exactly international law is. So for the CLAT examinations as such, we are not supposed to study each and everything, and not also the in-depth knowledge of these organizations and the concept is required, but at least it is expected from a CLAT aspirant who is preparing for undergraduate examination to focus to make a career in law. It is important that a person is able to understand the basic principles or the concepts in regards to international law. Because when we talk about law as a career, okay, if we talk about law as a career, first and foremost thing we need to understand is that it is also a very diverse career. You are not going to be only considered as an advocate or a lawyer post you have completed your graduation. There are n number of scopes. You have expertise. If you have expertise in intellectual property, something that we are going to study in our upcoming lectures. If you have expertise in international law, if you have expertise in constitutional law, then accordingly you can shape your career in that particular direction. So international law is also something which is very rewarding. And if you wish to shape your career and want to represent the country whenever there is any dispute with the international framework, that is in regards to disputes with other countries, neighboring countries, or maybe some cooperation is needed, some agreements needs to be drafted. So the expert in international law will be obviously consulted in order to understand that what are the rules and regulations that one needs to take into consideration whenever they are formulating any laws, or whenever there is any policy in regards to international law, or if there at all there is any dispute where which India needs to be represented in any dispute or any problems which is in relation to international concept, then obviously the knowledge of international law becomes very important. So, but when you talk about CLAT as such, okay, when you talk about CLAT as such, that particularly will confine your research and your study to the limited areas. And in that particular limited area, we are not only going to understand that what exactly are those limited areas, but also we will try to correlate it with the general laws that is applicable in India, that is the constitution, that is the family law, that is the contract. Because when you talk about international law, the main concept of international law is that laws which can be uniformly applicable in regards to whole world. For example, the example could be, if you have might have heard one one abbreviation, if we check, and that abbreviation is, WIPO. So when we talk about WIPO is World Intellectual Property Organization. So World Intellectual Property Organization, it was formulated in a convention that was held in Vienna. Vienna is a country. So the convention that was held in Vienna, in which it was informed that what exactly is intellectual rights and how these intellectual rights needs to be protected. So, and if you talk about another concept, that is human rights. Human rights. So if we talk about human rights, then obviously you will find mention of human rights in our fundamental rights. And almost every country has certain laws which are going to implement the human rights and make sure that every individual who are the resident or domiciled in that particular country is able to get those rights which are mentioned as human rights. So there is a uniform applicability of certain principles and laws which has been asked on the cooperation and uh, on different conventions, which provides that when majority of the when majority of the countries, they formulate a group, and after due deliberations and discussions, they come to a conclusion that, okay, this particular thing needs to be done for the welfare of the country, for the upliftment of the world. And then based on those conventions and based on those agreements, there is a creation of certain principles. Those principles get incorporated in the general laws or in the laws of the nation, and then those laws are implemented by the nations as such, keeping into the mind the main principles, the main object or the main agenda of why this particular laws has been created. I've just given you example. For example, if you talk about WIPO, which is talking about World Intellectual Property Organization, which ensures that everybody who has created anything by his intellectual mind, by his intellect, then that needs to be protected. That is a property of that person who has created it. For example, if we talk about this particular lecture also, this is something that has been created in the name of SATHEE. So it is the intellectual property of SATHEE, and all the things whatsoever will be done and whatsoever will be communicated is something which has been given in the name of SATHEE. So it will be the intellectual property of whom? It will be the intellectual property of the organization SATHEE. And how SATHEE gets this right, that whatsoever revenue, whatsoever income, or whatsoever advantage the one person may get by creation of that property, and once he tries to sell that property, once he tries to use that property as income source, use property for income source, then how will that person be able to claim those things? For example, if you have created a software, okay, if you talk about international, when we talk about intellectual properties, and yes, you might feel that we are getting deviated, and whether we are talking about international law or we're talking about the intellectual property rights. No, we are actually talking about international law. But what happens is that even if you talk about intellectual property, the history is such that it takes into consideration the international concept first, because in it was not developed initially in India itself. So it is not something which is native, but it has been taken and it has been incorporated because of the different conventions and which has been taken, in which India has also taken part. So that is why intellectual property rights has come from WIPO, which was also an international convention in which India took part. And then India thought that yes, it is perhaps important to recognize the intellectual property of the people who, by their application of mind, has created something which is going to be benefit for the society. So in order to have that reward, in order to provide reward to that person who has created that property, for example, somebody has sing a song, somebody has written a movie, somebody has found a place, somebody has designed something. A design can be a software also, or maybe a design of clothes, etc. Okay, so whenever somebody creates something, what exactly they are doing is they are providing, they are making any property which is by their own intellect, and that intellectual property needs to be protected. So those properties are protected in India by different frameworks like the patents, the copyrights, etc. But if you see that all these rules and regulations that is now been applicable in India, whether we talk about copyrights, whether we talk about whether we talk about patents, whether we talk about trademarks, whether we talk about geographical indicators, all of them were bought in India because of what? Because of a convention that took place in Vienna, which is the WIPO convention. And this is something which is can be related to international law. So all the groups, there are different countries, okay, say, so for example, if out of these countries, these number of countries formed a group, okay, and after forming a group, let's take an example of like G20, like BRICS, okay, like SARC, like ASEAN, okay, like uh, there are other countries also, okay, there's SARC, this is, then you have ASEAN, Association of East Indian Nations, okay, then other organizations which are there. So basically these organizations are an example of the groups that has been formulated by the different countries, and these countries have same governance structure, government structure, policy, etc., and have same goals. So for example, these are the countries who have developed, and now they feel like that because of our development we have caused a lot of pollution, and we need to control and restrict the pollution that has been caused by from our side. It becomes important to for these countries to formulate some laws. So once these countries form these organizations, they formulate some laws. These laws, once they have been given the assent that yes, these laws are perhaps important and we need to follow them, then these countries will incorporate those laws in their personal laws or in their native country. Okay, and that is something which is known as private international law. Private international law. And the laws that has been created by virtue of these conventions and that has been applicable thoroughly is known as public international law. So this is the only difference between the public international and private international law. This has also been sometimes asked in your question paper. But for you, as of now, what I'm trying to explain to you is that how the international law is important. How the international law is important. How is it important? So yes, we have a country in India, and we are working to the best of our limits in order to make sure that the country is developing. But why exactly we need to have this sort of development? Because we have a reference point, and that reference point are the different nations who have already developed and who are already advanced. So we want that, yes, we should also scale them according to their level, so that once we talk about an important role in in any area, so it becomes important that these laws should be there, which helps us to figure out that what are the things that needs to be followed and what are the things that need not to be followed. So if we take example, world war has caused a lot of defaults and lots of hardships and took away lots of life. So in order to make sure that these type of wars or external aggressions never happens, majority of the countries, they formulated an organization to make sure that, yes, the world wars or wars among the nations never happens. But what happened after World War? Once the World War got ended, there was a lot of retaliation and a lot of problems, because of which World War II also happened. Then after a certain period of time, yes, we are going to understand and discuss how exactly uh, the international law has evolved. But first, we need to understand why exactly is important. So World War II happens, and after World War II, we see that the organizations which were formed in order to make sure that World War II doesn't happen has failed. Because if they would have been successful, or they would have been efficient, then World War II would have never happened at the first place. So what we observed was that there is an important need of an organization which is strong enough, and which has gathered the consent of majority of the nations in order to make a unified laws that has to be governed throughout the country and by every country, in order to make sure that there is peace, security, and upliftment of the citizens of those countries. So that is why there are different organizations that are working in different aspects on different areas, which are helpful and which are working for the development of the world as such. The organizations, if we talk, who are working on different sectors, if you talk about international aspect, so we can get numerous examples. For example, if we talk about health sector, then you have World Health Organization, WHO, who has worked during the pandemic. If you will see, they have worked and they have researched over the different way forward. Different nations were giving their solution how to combat a pandemic. India also have provided their solutions, and WHO researched over the same and then provided a unified approach that how this particular pandemic can be fight for. And then you have other organization, which is IMF, that is International Monetary Fund. So some country has been taking loans from a different country in order for their development. For example, let's take the example, Sri Lanka is taking loans from China, or it is taking loans from India in order to develop that particular nation and in order to uplift it, because they are not having enough amount of revenue. Then it is the International Monetary Fund who is going to observe and analyze that what amount of fund has been transferred, whether the rules has to be followed or not. And why is it important? Because if at all, after a certain period of time, Sri Lanka, after borrowing the money, is not able to pay back that amount, then what will be the repercussions? How the lending company, the lending country is will be able to recover or will be able to sue the borrowing country. So all these informations, how the international framework works, everything needs to be understood. And that is why international law becomes a very important point of discussion, not only for your CLAT examination, but for your regular knowledge and understanding also. So if we talk specifically in regards to CLAT, now if we talk specifically about CLAT, then we will have to be focused over the syllabus that has been given and provided by the CLAT consortium. And in this video, we are going to see the overview structure of that syllabus, so that from the upcoming videos, we are going to start with the syllabus and what exactly needs to be studied. So if I suppose that you are able to see the screen that is in front of you, and when we talk about legal reasoning for CLAT, it is important that these topics are taken in a very detailed manner, because there has been questions which are obviously from depth in regards to these particular areas. So the first thing that we are going to study in international law is that first we'll understand what exactly is international law. What is international law and its significance and impact on a country. Okay, how is it important for a country? And the international bodies, major international bodies like United Nations, what exactly is the role of United Nations, World Trade Organizations, International Monetary Fund, World Bank, etc. Then how the dispute is settled. If there are two countries, for example, India and China, and if there is any dispute between these two countries, then how the matter will be resolved out. If there is one company which is situated in India, another company which is situated in China, and there is a dispute between these two countries, these two companies, then who is going to resolve the dispute? If there is a dispute between a individual X who is resident of India and an individual who is resident of China, if there is a dispute, then who will be competent to resolve that particular dispute? Who is competent to resolve that dispute is also something that we need to understand when we talk about international law. Because when we were discussing about constitution, so it is pretty much clear that the applicability of the constitution, and if you talk about fundamental rights, it will only be in regards to what? It will be only in regards to the citizens as such, the residents as such. But if there is a dispute between India and China, if there is any dispute between any company with the name Indian company and China company, then how the matter shall be resolved? Whether the rules of India shall be followed, or whether the rules of China shall be followed. All these things are going to be studied in our second portion, that is dispute settlement. Then we will be talking about international treaties. What are the different treaties, or how? Just I've given you an example. Let's take the example, if in the world there are this many countries, okay? And out of these countries, these the encircled countries have formed an organization or a group for upliftment, okay, and they have made a treaty. Treaty means an agreement which is which shall be abided, which shall be agreed upon by the organizations or the group to do something or not to do something, to resort to something or not to resort to something. For example, if I'll give you example, there is a PPP principle, which is known as polluter pays principles, in which it has been mentioned that the developing nations who are developed, and if they are already creating a lot of pollution, which is contributing to the depletion of the ozone layer, then accordingly they are supposed to pay compensation to the nations which are developing. So this is a concept of polluter pays principle, which is also a sort of an international treaty, where which the country who is developing shall be paid by the developed countries if they are polluting, and that particularly amount will be coming from common bank which has been created, that if there will be anybody who is causing excess pollution, they are going to provide remuneration, and that remuneration shall be used for the development of undeveloped nations. Okay, so this is the concept that we're going to study when we talk about international treaties. Then we are going to talk about humanitarian laws and UN Charter. UN Charter is very important because majority of the questions you will be getting from here, the different sayings that what exactly is international law, what exactly is international law. Different scholars have given different definitions in regards to international law and its applicability. So we are going to discuss those things also, because that also forms an important area of your CLAT examinations. So this is the almost a brief introduction in regards to international law. And there is one more concept that we need to understand, and that is law of sea. Law of sea means that if we talk about of the whole world, then you know that almost 2/3 of the portion has been occupied by sea. And if we don't have any authority over sea, then not only it causes a lot of security concern for any nation, because if by route somebody can try to get inside the other country, the foreign country, and then they can do malice, or if they have ill intentions to destroy the country, then there are high chances the security breach would be there. So there should be laws which will make sure and that will ensure that the there are certain laws that needs to be governed, and accordingly the sea, if somebody is sailing in the sea, what are the things that they should do and what are the things they shouldn't do, has been mentioned and enumerated in the law of seas, which is also what we are going to describe and understand in regards to your CLAT examination. Then you have state recognition. If at all there, if we get a state, if we get an island and it emerges out from the sea, and now that particular island wants to get recognized, and so how the whole world will recognize it, all the process, all the procedure, what are the requisites for a state to be recognized by the other states. For example, if I'll give you a hypothetical example for a better understanding. After a certain period of time, if you happen to discuss the Jammu and Kashmir issue, there are people, and if there is a dispute, if you have understood the dispute between Jammu and Kashmir, and how there's particular states obviously try to get independent status. So how, if is it possible for a state also to get independent status? How the procedure says, what exactly are the laws in regards to the state recognition if they eventually want to become independent state? What are the rules that needs to be followed? So everything has been mentioned under the state recognition, and becomes an important point of discussion. And whenever there is a territorial dispute, you must have heard that there is a dispute that is ongoing in regards between China and India in relation to Arunachal Pradesh. India has obviously claimed that Arunachal Pradesh is part of India, of Indian territory, but China has, by different institutions and different mechanism, by various actions in maps, has shown that some parts of Arunachal Pradesh belongs to them. So these type of territorial disputes, what exactly are these disputes, how the disputes are caused, and what exactly is the mechanism to resolve the disputes, is something that we are going to study in international law concept also. Then we are talking about terrorism, that what is exactly terrorism, how the terrorism needs to be combated. All these things is something that we're going to study in international law. And then last but not the least, we are going to study about the environmental laws. Environmental laws we are not going to study in detail, because the questions that will be put up in front of you will only be limited towards noise pollution, air pollution, and certain areas which is regarding to environmental laws. So I will provide you a gist of the story in regards to environmental laws, that there are certain case laws that one should go through and understand, and it will be more than sufficient for you to crack the examination. Because see, first thing we need to understand here is that in CLAT you are not supposed to study everything, but you should have a little bit of knowledge and idea of everything. Little bit of knowledge. For example, if we talk about how we are going to provide solutions in regards to contamination of water, international contamination of water, what are the remedies for it? Then, so if you go through the legislation, you will get Water Conservation Rules and Regulations Act. In the same way, Air Pollution Act, if we talk about Soil Pollution Act. So these acts are being created by the nations and the laws in order to protect the environmental and such. And it is not only being kept for the national importance, but internationally it is also being recognized. And just now I have gave you an example, that is PPP, polluter pays principle, is something which is an example of environmental laws itself. So this is what exactly is the syllabus of your CLAT examination, of your international law, a part of the subjects that we are going to study in our legal reasoning, which is part of the syllabus of your CLAT examination. So we will be starting first by United Nations. In the upcoming videos, we will try to understand that what exactly is United Nations, what exactly is the World Trade Organization, what exactly is the work of IMF and World Bank, and then other important organization. And we will study what is international law, and what is the statement of the different scholars in regards to international law. What has the different scholar like Aristotle, Bentham has enumerated, like Julius Stone has enumerated in regards to international law. This is also important because obviously there might be some questions which can directly ask that who has said this and who has said that. So for that, it is important. So this is how we are going to approach our international law. First, we will be dealing with United Nations, and obviously, if we are going to deal with United Nations, we are also going to deal with United Nations Charter, then the World Trade Organization, International Monetary Fund, and then you have World Banks and other important organizations. Post that, we'll be going to talk about dispute settlements, then international treaties, then humanitarian laws, then laws of the sea, then law of recognitions, then state recognitions, and environmental laws and other important areas of your international law. So that will be it, guys. I have explained you the overview of how the things would be and how the things need to be finalized whenever we're going to start with our international law. So I would recommend you that you kindly go through the syllabus and see the previous year question papers and analyze that what type of questions has been asked in regards to international law. International laws will only be confined towards some basic principles. Just in the previous video, I've informed about just cogents, pacta sunt servanda, and other latent terms which has often been asked in your competitive examinations. So we'll be going through it, and then we'll see to it that how the things would be favorable for you in regards to your preparation for your international law and focusing towards the legal reasoning areas. With this, I would like to thank you all again for being present in the video. In our upcoming videos, I've just informed you what we are going to supposed to be done, what we are going to do. And so let's meet in the next video, guys. And let's try to understand international law, and let's try to be more confident so that once we have prepared for this examination, the law examinations as such, we are able to pass with flying colors. Make sure that you're remembering the 3 principles that I have informed n number of times to you. So you stick to it, and trust me, if you stick to the mechanism and the curriculum which needs to be followed for any competitive examination, then nobody is going to stop you from clearing the examinations as such. With this, I would again like to thank you all for being present in this video. We will meet and we'll start with international law, the whole detailed discussion in regards to international law as such. Okay, guys. Thank you. Bye-bye.